Nigeria. My name is Aaron John Obizoba. To all our returning subscribers, we say a very big thank you to you for always joining in whenever a new episode drops. And to all new subscribers, we say a very big welcome to you. Don't forget to hit the subscribe button and turn on post notification so that you can always follow across new episodes when they drop. So in this particular episode, we'll be talking about something very remarkable and very interesting. That is yesterday's breaking news, which came from the Supreme Court. I'm sure you must have been aware that yesterday the Supreme Court did establish the financial autonomy of the local governments. Now, in Nigeria, by virtue of Section 7 of the Constitution, the local government is actually the various local government areas. The local governments are created, are established. Nigeria is a democratic state, a federal and democratic state. Now, when you say federal, it means there are levels, there are tiers of government. In Nigeria, we have the federal unit, you have the state, and you have the local government, which as the local government is recognized under Section 7 of the Constitution. Now, there's always been this running problem with regards to the administration of the local government, especially in regards to the fund and constitution of the executive of local government. You're very much aware that for those of us who are not aware, in case you're not aware, this you get to know from here. Ordinarily, Section 162, while Section 7 creates the local government, Section 162 provides for the administration of funds, federal funds. Another Section 162, particularly Section 3, there's this provision that the funds of the federal states in Nigeria shall be administered for the benefit of the federal, state, and local government level. However, in Section 162 sub 5 of the same constitution, it is stipulated that the funds of the local government shall be provided through this from the federation, like for the federal units through the state for the benefit of the local government. That provision is with regards to the fact that the federal government will actually send the funds, will release the funds for the administration of local government to the states, who will now disburse them to the respective local units, local governments, based on a formula or a particular method or a particular system that will be created by the National Assembly. So ordinarily, that's what has been happening. The federal government will release the funds to the state government for the administration of for disbursement to the local government. But there's always been this problem. Most state governments will not release the money. Now, don't forget, Section 7 established local government, which says that there shall be a local government with democratically elected officers or executives. But in Nigeria, you find out that the system is that governors will always, rather than have elections conducted for the election of local government executive, governors will always prefer to appoint their own person, appoint their own caretaker committee. So most times you find out that yes, you have someone who is not the choice of the people but has been appointed by the governor. So that's where the problem started from. The fact that there are no constitutionally elected representatives in the local government. Then by virtue of that, some states governments or most states governors have been abusing that power created by Section 162 of 62 sub 5 of the Constitution, which says that the money for the benefit of the state of the local government shall be paid to the state government, shall be sent to the state governments for them to disburse or administer accordingly to the various local governments. Most state governors will just receive the money, and because it's their person or their boy that is there, they will not disburse it as it should be. Once they just give you the ones they feel is necessary for you. That is why when you get to most local governments, nothing is happening. There are certain responsibilities that should be taken care of by the local government. There are certain local roads, there are certain community roads, primary school education, primary school settings, markets, some places, parks, garages that should be managed by the local government. But they are not doing it. Why? Because there are no funds allocated. Most times these funds come from the federal and the state governments sit on it. They don't administer, they don't disburse that should be. So yesterday, the Supreme Court actually gave a judgment. Now, recently, the Nigerian government, the federal government, through the office of the Honorable Attorney General of Federation, on behalf of the local government, instituted an action. Now, the rationale, the basic underlying factor was for the establishment of the financial autonomy of the local government. And beautiful as this, yesterday, the Supreme Court, in a well-considered judgment, basically established that the purpose of Section 162 sub 5, which says that federal government should send the funds to the state government for the benefit of the local government. The Supreme Court established that the purpose of that was to ensure that there was a very orderly system by which, yes, the funds will be disbursed and administered to the local government. But however, the state governors and government are constituting themselves to be a bunch of persons who want to actually thwart a democratically elected system. And most times, rather than release the funds, now I'm not quoting the Supreme Court, I'm just paraphrasing. Rather than release the funds, most of them are decided to sit on it. Therefore, inhibiting the true practice of a federal and democratic state. So the Supreme Court yesterday employed judicial activism. There's what we refer as what is known as judicial activism. This is when the judiciary takes it upon itself to ensure that you don't just interpret laws in a layman manner, but you do want to ensure that the tenet and obligation of the various laws are achieved. What is sought to be achieved, that mischief that is sought to be corrected, is properly addressed. Yesterday, the Supreme Court employed true judicial activism and ensured that, yes, they established that, yes, notwithstanding that provision in the Constitution that it has to be given to, it has to be from the federal, it has to be sent to the state government for the allocation to the various local government units, that the state governments and the governors have not been doing that. And as such, it's directed that henceforth, in order the federal government should send funds directly to the various local governments. Now, many people have been agitating, and the thing is, yes, by virtue of section 162 sub 6, the various state governments are supposed to have what is an account known as the state joint local government account, where monies will be paid, monies allocated to a state for the local government to be paid and to be administered to the several local government. Yes, they're supposed to have that. So that's why normally the federal government will send that money to the state, to the state, and the states will actually make sure that the money gets into that for disbursement. So now the federal government is saying that the Supreme Court ordered that, okay, this money should be paid directly to the local government, not again to the state government. It basically also established the fact, the Supreme Court reiterated and established the fact that local governments should have democratically elected representatives. It basically established that all those caretaker committees that have been created by various states are what? Unconstitutional and undemocratic. Yes. They're unconstitutional and undemocratic, and as such, any state government that still maintains that caretaker committee, no particular fund should come from the federal government, no allocation should come from the federal government to that particular local government until they have democratically elected representative. So what it means now, the implication of the judgment is that all local governments must have, if they want to still get federal allocation, they must have what? They must have elect their chairman and executive. It means that henceforth, federal allocations will not be going to the state government for the benefit of the local government. The money will be going from the state government and from the federal governments directly to the local government. So it was a very landmark. It was a very important and interesting judgment that came yesterday, because this thing has affected. If you look at, that's why if you look at most local governments, they are not growing. Most local government area and councils, they are not growing. You just find out that there's a local government chairman. What is he doing? Nothing. You're not seeing any work that is happening, because most times the funds coming are not as it should be. Most times you have governors who put in their persons or their man or their boy there, and they tell them what to do. But with this judgment of the Supreme Court yesterday, which established one, local governments and federal government as it is now to send funds directly to the local government and not through the state government. Two, establish the fact that the appointment of caretaker committees by governors in place of democratically elected representatives is actually unconstitutional. Then three, that any local government that still has caretaker committee will not get any, should not and ought not to get any allocation. You see, the short, it was a very, like I said, it is a landmark judgment which will impact a lot of things. Although there are certain questions and there are certain issues that may still come up. But like I always believe and I always say, let's take it one at a time. The judgment has come. Definitely. For Rome was never built in a day. They say a journey of 1,000 miles beginning with a step. So, from here, from this landmark judgment, we know that a lot of things will change, a lot of things will be adjusted. I'm sure by now there will be a readjustment as to how the various local governments can have an independent account to receive the various funds. But let's see how we play out, how things play out. But like I said, it's a very remarkable judgment, which if implemented, will actually go a long way in impact, because the idea of the local government is for the people to feel governance at the grassroots level. So you can't feel governance at the grassroots level if the local government is actually not duly established and on a very solid ground. It says once the foundation is faulty, the house must surely crumble. So unless there is a validly and duly constituted and well strengthened local government, the people will never enjoy governance and will never feel governance. So basically, this is it as it relates to yesterday's judgment. We are still waiting to get the full CTC of the judgment to be able to read the judgment. But so far so good. It's important that you know that to this extent, the Supreme Court has given a judgment in regards to the matter on the financial autonomy of the local government in Nigeria. And right now, you can say on the large scale, at least on paper for now. Let's see the implementation on paper for now. There's a structure for the financial autonomy of the Nigerian local government. So my name is Aaron John Obizoba. I hope you've been able to enjoy this episode, and I hope you stay tuned for other episodes. Don't forget to like, share, and comment if you have any clarification or have any questions. Let's talk together, let's reason together, and let's see how we can actually have a Nigeria that really, really, really works. Until the next episode, please stay blessed and don't forget to stay out of trouble. This is Law to Win Nigeria. Thank you.